Public Enterprises Minister Pravin Gordhan has announced that his department will be lodging an urgent appeal to set aside the judgment that was handed down by the High Court in Pretoria last Friday on load shedding. Last week, the court ruled in favour of ActionSA and 18 others to have hospitals, clinics, schools and police stations exempted from power cuts. Let's get some reaction now on this with the party's head of strategic litigation, Adv Gill Benson. Thank you very much, Advocate, for your time here on eNCA. Just firstly, your reaction to the fact that government has decided that it's going to appeal on an urgent basis to have the judgment set aside.
Well, we anticipate that they're going to appeal in terms of Section 17(1) of the Superior Courts Act, but our legal team haven't received anything as yet. So we can only speculate as to what the grounds of that appeal are going to be.
So when you say you anticipated that government would try and appeal this, were you anticipating that it would have the court or apply for the court to set it aside, or were you hoping that maybe the minister will try to appeal the fact that he was given only 60 days to make sure that schools, hospitals and police stations have power?
Well, I'm not sure what it is that they are going to appeal, which part of the judgment, or whether it will be in whole or in part. Despite the fact that it's a very costly exercise to appeal, and whether leave to appeal will be granted is another matter. One would have hoped that the legal costs involved, bearing in mind that there were numerous advocates briefed in the matter on behalf of government, that's money that could have been put to good use instead. But be that as it may, the actual judgment says that only reasonable steps have to be taken. It's not as if the courts are asking government to collapse the grid to supply schools and hospitals and security services with electricity. What I also found quite interesting, and I'm not quite sure how they're going to deal with it on appeal, is that on the last day of the hearing, the government filed a further affidavit telling the courts that since September 2022, so that's several months ago already, that they had already made a plan to take most of the hospitals out of the shedding areas, alternatively to give them alternative sources of electricity or power. So why they're appealing when they're the ones that advised the court that they've already dealt with hospitals, I'm not sure. As I said, it's conjecture on my part. I don't know what their grounds of appeal are going to be. I don't know if they take issue with the time frame or with the actual relief, notwithstanding having advised the court that they've already started making a plan. Perhaps they only have an issue with having to supply police services and schools. I'm not certain at this point, and we look forward to seeing what those grounds of appeal are and whether the court considers it appealable at all.
There are a number of hospitals that were already exempted from load shedding a few months ago already. But I just want to ask you, in terms of what we heard from Andre de Ruyter when he was still CEO and your papers were filed, right? He said that it's going to collapse the grid because it meant that money would have to be redirected from maintenance, which already is an issue, to make sure that hospitals, police stations, etc. are given that alternative energy supply. So what do you say about the fact that a lot of experts have agreed that it's not technically feasible to do what the court ruled that the minister or government must do?
Well, I think that, as I said, this argument became academic when counsel for government were advising us that they've supplied generators, they've already got alternative UPS systems. How is that going to collapse a grid? It has nothing to do with the power stations. We've seen that without even complying with the court order, which clearly they don't intend to do, we've already delved into stage 6, with most of us sitting with 11 and a half hours without electricity. So was it really going to make a difference? Also recall that on the 5th of April, they withdrew the state of disaster regulations.
Yeah.
If this situation was as bleak as they say it is, why did they do that? I don't know that I find any veracity in the allegation that it would collapse the grid. And it seems that on their version that may be inevitable in any event and has nothing to do with the judgment whatsoever, notwithstanding the criticism received that the ActionSA and the other applicants have been successful thus far. The fact remains, quite frankly, that the infringement is unconstitutional. So what do they then propose? They said that they had an energy action plan in the media statement on the 5th of April. We want to know what that is.
I want to come back to what you just said right now, that the fact remains that there is a constitutional infringement. There's a response to that. And just one little sentence on the statement by Minister Pravin Gordhan, and I just want to read it for you and you to reply. He says the judgment is going to undermine the very efforts to balance the protection of the right that were ventilated in this case. So basically talking about those constitutional rights that were ventilated. He says if government has to do what the court has said it must do, it's going to undermine those very rights.
How can allowing children not going to school, lives being lost in emergency situations that require healthcare, and not having access to police services when your own life is in danger, how is that undermining those very rights? That certainly wasn't the argument placed before the court at the time, and I look forward to seeing their grounds of appeal, but I cannot see how infringing rights is undermining the Constitution by disregarding this judgment. And as I've stated, spending this money that's going to be expended on the appeal, or at first leg is the application for leave to appeal, which is also, there's very limited grounds on which one can be granted such leave. It's going to be a very costly exercise, and it's going to delay the matter, unfortunately, for some months. It takes many dates for this matter to then be heard on appeal. So it's very unfortunate, and it's a sad day for South Africa.
So tell me something, Advocate. You said that the arguments were mostly academic. I think that's what I heard you say in the High Court. But government is clearly going the route of listening to what your engineers and experts in the energy field are saying, in terms of them saying that it's not technically feasible to be able to do this at the moment, because money that the court is expecting that government will give schools, etc., generators, and that means diesel. We all know how much is spent on diesel already at power stations. Basically, they are now arguing that. Is this an argument that they raised during this case, or are they only raising it now that the judgment has come out?
On the answering affidavits, it was the argument that was put forward. Eskom, to a large extent, took a back seat during the court case. But government certainly said, stop asking what we're not doing and instead pay attention to what we are doing. And here's an affidavit they call it the generator affidavit, where they tell us what they have been doing, and they applaud themselves for having taken action since at least September 2022 to provide healthcare facilities with alternative UPS and generators. They didn't come from the applicants, that came from government. So now why they're arguing, yes, but we're going to collapse the grid, that was never government's argument. Government's argument was primarily that it's the municipality's responsibility to provide power. I think when the fallacy of that fell away, then it was, no, rather look at what we have been doing and stop saying we're not proactive. We are. Now they seem to be trying to rely on Derator's affidavit and saying, well, the grid's going to collapse.
And I guess for ActionSA and all the other political parties and civil society organizations, I'm assuming that your argument also comprises the fact that as South Africans, we just want timelines. Because, I mean, the finance minister also did say in his budget speech earlier this year that they would also be giving people solar panels, etc. But that hasn't started. So I guess, in terms of making sure that the court has a judgment like this and even says in 60 days, that's what you're looking for. Because at the end of the day, if they're saying, don't look at what we're doing, look at what we have been doing, it's about how long it's taking. Am I right?
Correct. Like I said, it was only after the court hearing had concluded that the media statement was released by the Minister of Cogta and the Minister of Electricity to say to us that they've got an energy action plan, but that this hasn't been made available to the public. So what is your plan, and when exactly do you wish to, or when do you intend to comply with that? Why don't you tell us that and start using these funds at putting that action plan into place?
All right. Well, let's see what they say in their papers, and then we'll find out from you what your answering affidavits will be. And since it's an urgent basis, I'm assuming that the courts might actually call it unless they strike it off the roll on an urgent basis. Thank you so much for speaking to us here on All Angles. ActionSA's Head of Strategic Litigation, Adv Gill Benson.